you are not yet the member of Collective Counsel, I appeal to everyone out there that uh, please enroll yourself. It's a free membership we are offering as of now, and there are a lot of events that are lined up. We in our span of 1.5 months, we have done a lot of events ranging from mediation and all that. Today, the fireside chat, I am sure that it's going to be very interesting. So yes, I appeal to everyone. If you guys are not member of Collective Counsel, just it's a small process. A link will be circulated in the group. I'll request Hitansha to do that. Just fill up some small details into the link, and just be a member. We with open arms welcome you to be the member of Collective Counsel, and we look forward to today's session. I again welcome all the speakers, Richa ma'am, Mr. Bhosale, and everyone out there. And let us see and let us hope. We have exciting events coming up. We are in a process of developing a campus ambassador program, wherein even if you at any year of your study, you'll be enrolled as a campus ambassador, and there is a lot of exciting things to be done. So thank you so much, Itansha, for just giving this small space for me to come and introduce Collective Counsel and membership department as a whole. Thank you.
Thank you so much, sir, for the warm welcome and warm explanation about the Collective Council and specifically membership and outreach department. And I request everybody to fill in the membership form and see what Collective Council is doing and contribute as many as you can. I'm assuring you that you will learn a lot of things from here. So definitely it will be worth of your time and energy. Thank you so much. So let's start with fireside chat session now. Thank you.
A very warm welcome to all of you. Today we have a privilege of hearing from Dr. Chinmay Bhosale, a scholar, a powerhouse litigator and innovator, and a thought leader in criminal, commercial and economic offences. I am honored to introduce a man whose journey combines academic brilliance, courtroom victories. Dr. Bhosale is a gold medalist graduate from ILS Law College, Pune, consistently topping in his class at Pune University, a testament to his exceptional dedication from an early stage. He followed this academic excellence with leading roles in mooting and advanced diplomas in topic ranging from medical jurisprudence to human rights. What truly set him apart in his PhD in law on the subject of malicious prosecution, making him one of the India's youngest litigator scholars to earn such distinction. Today, Mr. Bhosale is the co-founder and partner at SRB-OJAS, which evolved from a 40 years old family firm into one of the Pune premier litigation practices. Dr. Bhosale is also a lively voice on critical issues, be it cybercrime infrastructure, data protection, remedies, courtrooms, AI impact on the legal profession, or the nuisance of criminal registrar reforms. Beyond his professional achievement, he is an inspiring mentor. He founded the Dr. Suresh Chandra R. Bhosale Legal Excellence Gold Medal, fostering and recognizing excellence among students at Pune University, a tribute to his commitment to legal education and his family legacy. Speaking with clarity, purpose, and guided by intelligence, Dr. Bhosale stands at the distinction of scholarship litigation. Please join me in welcoming a true thought leader and immediate legal practitioner and today's honored speaker, Dr. Chinmay Bhosale. Now I would like to invite my fellow volunteer, Kanak Pandey. Thank you.
Thank you, Sneha. It is my deepest honor and privilege to present a renowned and respected personality in Indian legal community, Advocate Tushar Khairnar, sir. Mr. Khairnar is an advocate on record at the Honorable Supreme Court of India, a designation that not only speaks of legal competence but of a great deal of integrity, dedication, and accountability in handling clients before the country's highest court. He is a first generation lawyer as well, whose inspiring career is the law is a definite proof of tenacity, zeal, and objective. He is the founder of Ethics Legal and respected law firm and headquarters in New Delhi, recognized for its client-focused approach, ethical values, and abiding commitments to justice. In the last 9 years, Mr. Khairnar has developed a rich and varied litigation practice, successfully arguing a wide range of civil, criminal, and constitutional cases in numerous forums, such as trial courts, high courts, and Honorable Supreme Court of India. Apart from his practice of litigation, Advocate Khairnar is also a committed member of the Supreme Court Legal Service Committee, where he maintains an active role in rendering free legal aid and making justice available to the weakest and most marginalized sector of the society. To complement his courtroom skills, Mr. Khairnar is a postgraduate diploma holder in alternative dispute resolution in Mumbai University, which enables him to settle complicated legal disputes not just under the conventional litigation model, but also through more participative, efficient, and timely alternative systems. His work reflects an uncommon blend of professional distinction, scholarly legal, and profound social conscience, and he remains an inspiration to young lawyers and law students everywhere. Everyone, please join me in giving a warm, respectful, and enthusiastic welcome to respected Advocate Tushar Khairnar sir. Now I like to invite my co-volunteer Shefali for further information.
Thank you, Kanak. We are pleased to have Richa Bhardwaj ma'am as the moderator for today's session. She currently serves as legal counsel at TechMonks Corporation, where she has been leading legal efforts on a variety of technology, contracts, and compliance matters for over 4 years. With more than 15 years of experience in the legal field, her work spans commercial and corporate law, data privacy, and intellectual property. She has consistently helped organizations navigate complex legal frameworks, offering strategic solutions in areas like compliance, dispute resolution, and governance. Along with this, she is also passionate about empowering businesses through practical and effective legal solutions in a constantly evolving legal landscape. We now invite Richa ma'am to kindly take over the session and share her insights with us.
Thank you, Collective Counsels and the volunteers, for the warm welcome. I hope I'm audible. As I read the introductions, I found one thing common with the speakers and myself is that we're all studied from Pune. I studied from DS Law College, and Mr. Khairnar also studied from the same alma mater, and Dr. Bhosale is from ILS. So now let's start from the beginning where we all started, is how we decided to pursue law. So I request Mr. Khairnar to enlighten how did he decided to pursue law and how did his law shape and
Yes,
earlier was DS Law College, now Naval Mal Firodia DES Law College.
yes,
Um, and his experience there and his journey from Pune to Delhi has started.
yes, ma'am. Yes, ma'am. Thank you so much, ma'am. It's really honor to having a senior from the same college, and it's really privilege to having this
My
prestigious
pleasure.
institute of the Pune because of, we have lots of memory from the just because of the uh, college or those days. It's very important for the uh, remembering the days where you don't even know about where you are going to be doing a job in a law firm or doing a litigant practice or not even know how to talk before the court or even not even know how to enter into a court.
That's
It's
true.
yeah, yeah, it's something very different that from those days to the present day where we are we are taking briefs and standing for the clients. It's really I don't think so. It's a long way, but it is a just a way to we can say that yes, fulfilling your dreams and just enjoying your own time where you want to be or where you dream about it in your life. So I must say that the as a first generation lawyer, it never part or never thought in my dream also that one day I will become a Supreme Court practicing lawyer, because it's a bit difficult task, because I know that where I'm standing today, but it's starting from the that college days. Then eventually I shifted to after the Pune. I shifted to the Bombay High Court, where I started as a practicing advocate at a session court and the High Court, and then subsequently uh, I I just developed some interest before the Supreme Court. So initially, I decided to practice over in a Supreme Court, but it's a bit difficult for the first generation to getting a matter. So therefore, I decided to go for the Aragon record examination, and it's like the fortunate for me that I appear on a first attempt, and then I got clear also on a first attempt. So it make easy for me to continue myself in a Supreme Court. But the if I consider myself as a student to the practicing advocate, I may say that it will start from the very beginning days of my college days, where uh, if you do remember that I don't know if he's from the subsequent band, Mr. Kulkarni, Prasad Kulkarni. He's a practicing advocate in a Pune. He's a very renowned lawyer in a Pune. He's a criminal practicing advocate. So he was there for he taught us some criminal laws like CPC and IPC. He was there. So what he said that the yes, it's not just about the whether you are going to be a first generation lawyer, second generation, because he was a first generation lawyer. So he when we started our lectures, and he's a practicing advocate, so he just come over there just to do teach us that the how the actually law work when you become a lawyer. So yes, so what he is going to say that if you guys want to go before the court, any court, he most probably he say that it just go before the we say that in Maharashtra we call it a judicial magistrate first class courts, where the offenses below the 3 years punishment will trial by the court. So he said that do one thing, don't understand anything, don't read the law, just go before the court and just observe that what judge is going to say, which kind of cases coming to the court. So it will give the very basic detail about the what actually happening in a court. If you just want to be a practice in a court, and if you don't want to be a practice, then he said that don't you don't need to study. You just do one thing, that you have to be a just one thing, and that is about the you just focus on a good English. That if you do want to be a just do a good job at a good law firm. But being a litigation lawyer, you must have to be very smart. You have to be very efficient about the multitasking, because simultaneously you have to dealing in a judges also, and simultaneously you have to deal with your client also, and you have to convey the dismissal order to your clients, and it is your skills that how you convey the dismissal order. And the same thing, even though you got some worst case that you know that it's going to be dismissed, but it's your task that how you can convey those facts to the law judges, and how you put before the any worst fact into a efficient case that will make you the such some better judgment or some better relief you will get, that the which you never imagined. So what he was saying that yes, it is a bit difficult task for us that as a lawyer, not about the first generation, second generation, but as a lawyer, for the first 5 years is very important. For first 3 years, out of that, you have to just think about it, whether I'm able to do the practice, and our mindset is just tackling ourselves that whether I'm eligible, or even though I'm able to stand before the court, even though I'm able to understand the cases or complex situation. And then next 2 years is very important, that if once you pass through the first 3 years, then next 2 years you have to focus on that. Yes, now I can survive over here. Then next 2 years you have to just think about it, that there's okay, you now you're surviving 3 years. Now it's all about you, that the how to earn something which can make you the sustain your practice. So that's first phase, that you have to do one thing, that it's not about the become a rich, or not become a, just like the you have to start starving for the food. It's not just about it. It's about the take the money which is required. It's not above or not below, but minimum requirement. That if next 2 years, after the 3 years, it's a very important about the earn something, because unless until, even though you like to it's you're passionate about the law, but the most important part is about the earning sustainable practice. You need a financial resources, and if you do not have that resources, then I don't think so. No, not even a 1 year you can continue your practice. But the so what you said, that the first 5 years is very important in your phase, that make you sure that you're going to be litigant lawyer. And if you sustain for the first 5 years, then ultimately it's going to be a like the you have now become a part of the most rarest part, or most rarest number of the law students, because out of the 100 students, he said that the only 10 are become a litigant lawyer,
Yeah.
and only 8 to 5 going to be continue their practice. So if you guys continue to the practice for the first of 5 years, even though it's some downfall over there, then some bad experience over there, some good, you meet good people also, you meet a good judges also, even though sometimes in your good cases also you got a dismissal order. It's just like a part of practice, but the most important part is about the your mentality about the continuation of your practice. Even after the you got some bad experience, even you got a worse judgment, even though you're not even sometimes it's it's ground reality. Sometimes you just feel that you're not even getting a matters. That's a reality. But the thing is about the, even though it's the most important thing is about the, even though in a month, in the initial days, you got a one matter for the 1 month, but it's important that the whether it's going to be a sustainable thing, that the rather than nothing you have something. So just focus on that. Yes, I got a one matter, then just give you 100%. That make you give the another brief. This is the my personal experience. I may say that the yes, initial days it is just like the, it's I don't think so it is we can say that the struggle, but it is a, it's just compare yourself that the, if one person having a matter, and if you have a choice that the these things deal by the some senior, like he's having a 7 to 10 years practice, and the one person who just have a some month practice, like the 7 month or to 1 year, then ultimately as a common man we think that the, yes, if I have a good case, then how can I trust someone who's just come to the practice? You not even understand the how the draft, how to deal with the judges. So it's just a part of practice, and we can say that it's not struggle, but it's a mindset of the society that they will not trust easily to those who just become a lawyer, who just initiate their practice and just become a litigation lawyer. So I may say that the yes, those are things we have to accept those reality also, but simultaneously we have to accept that is what I want. That's the most important thing. So I may say that some people will just become. I may say that the in a college days we say that yes, I learned the criminal law, I learned the constitution, now I know the everything. So whether I need a senior, that's the most people will think that I can read the cases, I know the how to read the judgment. Whether I need a senior with under whom I can learn the court procedure, court decorum, or how to plead, or because sometimes what we can say that I don't know present syllabus, or how they're dealing with the cases, how they're dealing with the students, how syllabus of the present to a batch. So I must say that at my time we feel that the college syllabus is not sufficient for us to practice as a lawyer. We always think about it that the when I become a lawyer after the student phase, our message is that the you have to learn everything, that the how to read the judges, how to read the judgments, and how to talk with the judges, and how to maintain a decorum of the court. And the most important part is about the what exactly judges want from you when you presenting your case, what exactly they want from you. Because everyone, it's simple. In every case what we are doing, we are doing just putting the facts and just mixing with the law, and we putting this before the court. So this can anyone can do. Even a first year lawyer also do same thing. Even a 10-year experience also do. What make difference? The most important part is about the experience. So experience is about the making the 1 hour argument and making 5 minutes argument. But the most important part is about the effective argument. So how you can learn the effective argument? So it will start with the senior, your senior. So our message is that the even in my college days, about my one colleague, he always think about it. He's a very brilliant student. I must say that he's a topper. So what he done? He started his practice without any senior. So after the big after completion of the law, he started his own office without senior, and he just show up like the yes, now I'm doing my practice. So he purchased the whole the barracks and something like this. He did. It's good decorative office. But the what happened, and at that moment we are all decided to do the juniorship. So I joined the Bombay High Court senior, and my other friends joined the Pune bar. So what make difference? Eventually, what we realized after the 6 years, after the 6 months, I may say that the 6 months to 1 year, this person completely stopped the practice, and now, right now, not even he is not even a touch in the law. That's a grounded. He's a most brilliant student. I must say that they. But that make difference because even though you have a brilliant mind, you're very sharp. He's a good in English. He good in a drafting. Everything. He knows the law. Everything. So you just ask the question, he give the answer. But what? So we are. I must say that we are in my batch. We all the my colleagues who are actually in a practice, we are all the backbenchers. We are not on a toppers or not even a. We say that we are the top. Like say that we know everything. We never participated in any moot courts. We never did not even a single moot court. We never regular in a college. But I must say that still we are doing good practice. So what make difference? It's not just about the how much you know the English. It's about the it's about the the fancy words to influence your drafting. It's not just about it. It's about the how you are dealing with the your facts, how you can presenting those things before the court, and most important that the third part is about the whether you are getting the good order after your presentation.
That's so true, Mr. Khairnar. That reminds me a very famous quote that when the college started, it was started with the chairman under the chairmanship of Professor Deshmukh. He used to say the lawyer is a jack of all trade, master of something.
Yes.
So that was so true. And lawyer is so much more than just a person who knows law.
Exactly.
Thank you for such a well-rounded answer.
Yes, yes.
Going to Dr. Chinmay Bhosale, I would like to ask you pose the similar question. From the root, how did you decide to pursue law, and how the law school uh, shape your career choices, right from Vaishali breakfast to ILS Tapri and everything,
Yeah.
the whole.
So, good evening, everyone. So, basically, my journey was slightly different from Mr. Tushar's, maybe because I am not a first generation lawyer. I'm the antithesis over here, probably. But I really appreciate the effort which is going down over here in Collective Counsel. So, I'm a third generation lawyer, come from a pedigree which has made sure that I there was no chance that I would have been noticed. Natural. BF background. Thankfully, that was not the situation. It was rather the other way around, probably knowing the rigors of our profession. My father really wanted me not to come into the profession, but it was my choice to join it. So that's how I came into law. I started my 5-year law course at ILS 20 years ago. Managed to get out of it with a gold medal. Then I did so back then. Thankfully, there was no compulsion of attendance. So I had started working at Bombay already with senior advocate Mr. Mundargi, Ashok Mundargi, and I did my law at ILS, but that was barely attending any lectures. I was around only to give examinations probably. The rest of the time I used to be in Bombay working as an intern with him. I passed out from ILS with my 5-year degree. Then I preferred, while I was studying, one important thing maybe for these young lawyers was that having my academic background of topping throughout and my excitement as a young law student to go abroad to study law. I had applied to colleges, obviously gotten through them as well. I was also the I was also the Rhodes finalist back then of that year. But somewhere having that experience of interning throughout for 3 years with a senior advocate at Bombay made me realize that just adding a degree from a reputed college abroad is not going to really help. If I want to litigate, it's eventually the courtrooms and the corridors of courts which are going to help me, and it's better to be there as much as possible. So I took a call to not go abroad to do my masters. I preferred to do my masters from the Bombay University while I still worked as a junior lawyer over there. After my sanad, I jumped from Mr. Mundargi's chamber to senior advocate Satish Manishinde's chamber. So as a lawyer, I worked with him. He's a renowned name in criminal law. That was another experience which shaped me. Around that time, I completed my master's as well. Then I preferred to do my doctorate in malicious prosecution from Pune University, and then I did my postdoctoral from Howard Law School in negotiations and dispute resolution. So that has been my academic journey. Principally, I would say that that journey was shaped because of my practical experience, which I decided to take from an early stage. So I think from my third year itself, third, fourth, and fifth year, all 3 years, I used to be in Bombay working with a senior advocate, which really gave me the first-hand impression of what really happens in the court and what are my likings. Because essentially, what is also material in law is like two things are absolutely material, I feel. One, to shape your career, you need to understand what's your calling, because there are thousands of laws and n number of practices that you can do. So what is your calling is something you need to understand earlier, the better for you. So thankfully, prior to actually getting the degree, since I had worked sufficiently, I knew what is my calling, because before these 3 years of criminal law internship, which I really loved, I had also successfully failed at doing a civil law internship with a couple of seniors, and I knew where my liking was. And second, and so that's one part, knowing what's your calling, which is going to help you very early on, and that's why it also shaped my academic career later on after my bachelor's. And second thing that you really need to know is it's not as material to know what to speak, but it is very material to know when to stop. So that is very, very necessary in our field. So that way, making right decisions, uh, stopping where you should, rather than going in the uh, direction where everyone wants you to go or expects you to go, is something that you really need to understand. So that's how my journey has been. It was a natural law came as a natural choice, and I'm here since then.
Dr. Bhosale, for rounding up so well. So it's important to know where you're going and enjoy your time during the college years to explore all the options that are available to you. Now, moving on to the second segment, I would request you to give one example of something that you could have known while studying law, before studying law, for the students here?
One thing I would have really loved if I was a student is something from the practical aspects of law. Unfortunately, we focus too much on the non-procedural aspect of law in law colleges, and we are only taught maybe jurisprudence and the theories and everything, but there is barely any focus given on the procedural aspects. And 90% of the matters, in my experience, are won or lost on your expertise on the procedural law. So that is something I think had I known better while I was in law school, or I was taught better, maybe it would have helped a bit.
I pose the same question to you, Mr. Khairnar.
The difference between these two things, I guess so. The most important part, I feel that that's a time for reading the judgments.
I totally
That's yes, yes. Though
agree.
even a college days, I can say that we have a much more time to give the time for the reading the important judgments. But right now, even I feel that yes, it's required. But the due to the drafting work or the other duty bound work, I was just missing those days that right now I'm not able to give that much time for the reading. So those things are missing.
I totally agree with you.
Yes, yes.
So moving on. So I think the takeaway for this segment was knowing the law, knowing the practical aspects of law, and reading, which is very important.
Just to add on that point, I remember when I was starting law, I used to hear from other seniors of the bar what Tushar just mentioned.
Mm.
There was a senior advocate from Maharashtra bar. He back then was a very renowned criminal lawyer. He used to tell the entire bar every time that irrespective of how many hours of work you put in every day, before leaving your chamber, you should read one weekly at least, and then step out of your chamber. It doesn't matter what is the time, you should do it and then
Yes,
step.
yes. Even so, we dream about it. Today also, I dream about it. We can manage those time, but practically, it's really impossible task. Even though sometimes we just right now as a practicing, even we quoting some judgment, 3 or 4 judgments. We're not even able to read those 3, 4 judgments. We're just reading those relevant paragraphs and just focus on the facts and just relevant things. But I don't think so. Even 3 judgments, we not even able to read the completely. In that, that's a
The older
yeah,
generation came
yeah.
with a lot of patience than us, I guess.
That's
Yeah,
so true. That reminds me, though I'm a moderator, I'm less of a speaker here, but I would like to share an anecdote. Back then, when I was working at Bombay High Court, there were two brothers. They're still there. They're called Turzapurkar brothers.
oh, yes. So,
And the very unique thing about them is sometimes their matter clashes. One is sitting in the court, other has to go another court. They can argue the other brother's matter just looking at the small brief which is maintained by him, because but that comes with the power of reading and experience. And I have seen Mr. Chinoy and many other Mr. Harish Salve and many other lawyers. They have come sometimes rushed into the court, even they don't have the brief, and they have argued for hours together. And think that comes with the with a lot of reading and experience, of course. Moving on, can you enlighten us from your professional journey some nice anecdotes and some important cases that like acted as a turning point of your career? Same question for both.
okay. Sir, please.
Go ahead, Tushar.
Sir, you first. Ambassador.
Uh, I think for me, there were a lot of situations which really helped me uh, bolster or turn around my career, I would say. The earliest memory I remember of something which really helped me understand that criminal law is litigating. Criminal law is what my calling is. During my internship experience with Mr. Ashok Mundargi, I don't know whether these young boys are well aware or not, but he's one of the largest giants of the bar at the Bombay High Court, and commands a great expertise and fame on the criminal law side. So while working with him, I remember there was a bail petition that we were contesting, and it was a double murder it was a double murder allegation. The person had been rejected for bail in Pune High Court, in Pune sessions, and we were contesting that order in the Bombay High Court. One particular instance which had happened back then is that I used to stay there in Bombay, work at his chamber, and go back to the hostel and be alone for nothing to do any which ways after going back. So I had requested sir to take the brief back home, try to study a bit. And being a murder trial, I remember I had tried to dig into the medical jurisprudence aspect of it. And somehow I could understand from that one night's understanding that rigor mortis, which is a concept of the dead body decaying, is something which the concept of rigor mortis sets into the body after 12 hours, 12 to 16 hours. And this particular body that was found was in waters, in which case the rigor mortis sets in way later. So the period which it takes for rigor mortis to set in and the time period which was mentioned in the FIR was not matching at all. And that was one point on which we could convince the High Court that the FIR was coming with lacunas and it was a fit case for bail. And that particular instance, the encouragement that my senior gave me was phenomenal. I remember him expressing his happiness on the work that I had done to the entire bar. I remember him calling up my father and telling him, I don't know how many of you are Maharashtrians, but then there is a saying in Marathi which says "Pani vadnavarach jata," so blood eventually takes its own journey, and that was something which really helped me. So from such inspirations that my seniors gave, even with Mr. Manish Inde when I was there after my sanat, there were endless experiences. I got to work in 2G trial. I got to work in the largest trials of this country while I was at his chamber. And the encouragement which I've got from all these seniors was something which really, really shaped my confidence and my career in general. One particular case I would say which really shaped my growth trajectory or the name that I could eventually get was from one of the noted trials of our state. It emerged from an incident which happened on the Pune-Mumbai Expressway. I guess quite a few students who are here right now or young lawyers, they might not be born or they were barely born back then. In 2011-12, there was an incident on the Pune-Bombay Expressway wherein the police had conducted a firing on a large mob which was of around 2,000 to 3,000 people. 17 people died. The entire Maharashtra State Assembly was up in roars, and there was a inquiry commission set up of a High Court judge to inquire into the matter, and the entire state government was in quandary. Had it been proven that the state government ordered these firings, it would have been a chaos, and I think the entire state assembly would have been hung. And that was one particular case which I was representing the entire police force. And successfully defending them in this entire issue is something which really gave the experiences that trial gave me were phenomenal, and the exposure and name and everything that it gave me really turned the tide. That particular case not just taught me how to deal with the law, but it also taught me how to deal with the pressures, how to deal with the media, how to deal with other non-law issues that a lawyer has to face at times, especially if you're doing litigation and that to criminal litigation. I remember during this trial, half the courtroom used to be filled by opposition MLAs, MPs, MLCs. They really wanted to see where the government might have gone wrong, and everyone would be stepping out and giving their bites to the media. So handling that pressure, making sure you don't make any mistake, keeping your calm in that entire chaos is something that law school or courtrooms or anything is not going to teach you. But for a litigating lawyer, remaining absolutely calm in chaotic situations is something which is absolutely material. And that really helps you in your journey. So such incidences have really shaped right from my young age, my journey. And it really contributed to where I am.
It's it's muted.
Thank you, Dr. Bhosale. Mr. Khairnar, we would like to hear your thoughts.
Yes, ma'am. Actually, when doing a juniorship, I got opportunity. It was a case of the illegal termination of the pregnancy. It was a Sangli case. I was doing juniorship with Advocate Umesh Mankapure. He was senior to me. So there was one case. Two doctors, both they are couple. So what they are doing, they terminated around 5 to 600 terminated the pregnancy just because of that the just because of the child just due to they are a girl child. It was just worst case, but it was a sensitive thing. But and Mr. Bundagi was there. He was a senior counsel to us at that time, and he wasn't there. He had some personal difficulties, so he wasn't present over there. And at that time, Justice Samre was there. He dealing in a criminal law, and he dealing in a regular bail application. So he gave, Anna was there. My senior told me that you just take a date because of the senior is not there. And Justice Samre given just two things to me: whether you have to argue or I'm going to dismiss it. So ultimately, I decided to just go with the facts, and I given us some factual. Even though I know that it's not just about the morality, it's about the what exactly happened, what evidence we have, and what our role. So eventually, we are argued for the hardly for 5 to 7 minutes, but he impressed and he given a bail to our client. It was the most impressive thing to me, and actually that was the day when I decided to go for the solo practice. At that time I was doing a juniorship, so that was the moment. And then when I within 1 month after that case, I started my own practice, Bombay only. Yes, Bombay High Court. So, and the coincidentally, when I started my own practice, within a 3 days, I got a one mobile application that Bombay Session Court, and it was a POXO case. And what a coincidence that it's within 3 days. He was arrested before the incident happened 4 days back, and next day he was arrested, and within 3 days, I got a bail in a POXO case. So it was just it's just like some we say that the miracle, or we say that it's just go with the things that the which ultimately attracting towards you, that they positively happening with you just due to the you are doing your best way. So those two things really I never forget about these two things in my entire life, even though I got a big matters or something like this. But those two things, because they're gonna be initial confidence that yes, I'm made for it, and I have to continue my litigation practice. So those three things. And I must say that recently handled one it's we say that sensitive things, that the farmer protest matter that happened in a Delhi border. So Sindhu border, some farmers are doing a protest for the. They have some. It's just minimum price, something like this. They have a demand, but at that moment, I represented the local residents who actually facing pretty much difficulty due to their protest. Who are the local, because their transport is stopped by those protesters, and even though they don't have any travel chance, because some of the students are not even able to travel to Delhi. And most important part is about the medical emergency, because they block the highway itself.
Yeah, highway was blocked.
So I represent over there. It's going to be eventually Justice Suryakant was there. So what he done, he eventually do with one thing, that he just rather than just passing the order or direction to the government, what he done, eventually he do one thing, that he goes step by step. So eventually he talk with us. Eventually he talk with the he performed one committee of the that Punjab government, that is some agriculture college over there. So he formed a committee of the professors, not including lawyers or police officers or any judges over there. So they will talk, and now the all issues is over. So it will give the good uh, we can say the moral confidence, because the thing is about, it's not just about the winning or losing cases. It just gives the, I just learned one thing from my own experience from this. It is not just about the deciding the cases.
Yeah,
It is just about the how you're dealing with the situation. And now now I think that it, why I'm thinking about it's very important thing. It's about the what one judge want from you. They just don't want to be law from you. They don't want to be a reported judgment or relevant judgment. What they want what and how we can resolve those things. It is not about the petitioner side or respondent side. It is about the how we can resolve those things and how we can come to the conclusion. So these three things are message at the it's the most important part, and I message that the most important milestone in my journey.
Such awesome anecdotes and cases that you both have uh, handled in your career. Any failures or obstacles that shaped your career? And we all talk of the success stories, but failures are the one who teach
Yeah.
us more. That's what I think. So, not failures exactly, some obstacles also.
Yes, yes. I may say that the obstacles is about the getting matters. That's the first obstacle. Being a lawyer, it's a first obstacle as a how people will trust you when you just become a lawyer. That's the most important thing. Even I agree with this that the even though you are a second generation or third generation, it is not just that much easy that the you are just a son of the lawyer or a son of the judge. People not come to you and hand over the brief. No, it's not that much easy.
Yeah, it might help you get the first matter, but not the next one.
No, 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 no. I'm not saying that is not a reality because
That's
it's just
true.
easy to. But why I'm saying this because of even though I'm second generation or third generation lawyer, but it is just about the if my brief is going to be handled by the one lawyer who just having a 1 month or 6 months experience, and the same matter is going to be handled by the even though he's a first generation lawyer, but he's having a 1 or 2 years experience, so people will refer to the experienced person, not to the freshers. That's a reality. That's what I'm saying. And what the first generation, what the benefit of the second generation lawyer get, that they will continue the already filed the matter, which is already pending. They have that much privilege that they will continue the those matters which are already filed by the family member. But it is not about the but the for the getting the new or fresh matter for themselves. It is just like the same struggle for the all person. That's my own experience. Even though I have a friends whose father is a now sitting judge, so I do know that they are struggling. Even I met last week also to him. Still he struggling. Still he practicing before the metropolitan magistrate because he know that he will not get even a matter before the session court. His father was the retired high court judge. So it is that's my experience. But being a even though even my experience as a high court to the Supreme Court, I may say that there is an obstacle is about the how you can make connections because of being I'm a Supreme Court practicing advocate. I may say that my first client is not about the directly who party who actually having cases, but my first connection I must have a connection with the practicing advocate who having a high court practice. So you have to learn those things. So obstacle is about the how you can make a connection because I'm staying in Delhi, my office is in Delhi. So how can make a connection if someone is practicing in a Calcutta High Court, even someone practices in a Allahabad High Court or someone practicing in a Nagpur High Bench. So how we can make connection? So those are the obstacles, and still I'm trying to figure it out. It's not just about the solution, but I'm still trying to figure it out. That is how I can make more connection. How can I uh, make increase my reach towards the litigant practicing advocates because it's what I learned towards all these things like the litigation practice. If you're practicing in a district court, you must have the connection with the local businessman or the politician. But if you're practicing in a high court and supreme court, you must have a connection with the lawyers. If a practice, so I must say that this is the obstacles in a higher court practice. And the
That also
second,
happens because of the appellate jurisdiction. You
yes,
need connections with the lawyers.
because it's a very simple formula that the if someone want to approach to the high court, first where they reach to their own counsel who practice in a district court. So how this journey will start and how this, so unnecessarily you have to enjoy those things, but yes, on a practical aspect, it is just about the making bit difficult for us that if you are practicing a top level court, apex court on a high court. So I may say that it's your ability to make good connection and connection with the relevant people. That's it's not just about the making connection, but the I may say that yes, this is the obstacles, and the I may say that it will take at least 5 to 7 years. Not that much easy. Yes, yes, yes.
So I think I agree completely with Tushar. Getting briefs is the biggest obstacle for any lawyer. And second obstacle I would feel is understanding relevant uh, aspects of law. Many times people end up with so as I think even Tushar mentioned this, these days all the young lawyers have the thought that if I have read some case laws and few laws while I was studying law, probably I could go in all out on my own. But the first very relevant obstacle is not getting the relevant experience or relevant knowledge of the corridors of the courtroom from a good mentor. That is a very prevalent issue that many young lawyers face. Uh, and as rightly pointed out by Tushar, having briefs might not essentially be stating your expertise over law or your relevant experience. It could also be that you are very good in connecting with people around, and that's how you have garnered briefs. Unfortunately, it's very difficult for a young lawyer to tell whether the senior that he or she wants to approach has what it takes to teach you the relevant aspects, or the briefs are there because of the connections that have been established. So that is one of the major obstacles: getting a good mentor or friend or confidant or colleague to guide you through your initial years to get you the relevant experience, the relevant direction. That becomes a very big obstacle for everyone. And
Yes.
I think second point that I think was asked was what were the learnings from debacles or mistakes or negative aspects that we might have faced during our careers. So I feel the biggest learning for me from my mistakes was that as a lawyer you should know. So I am a criminal litigator at heart and core, and uh, I am one of those rare breeds or almost extinct breeds who still love to cross-examine, still love the trials on the criminal front. And one of my learnings through my mistakes has been you really, really need to know what not to ask during a cross-examination. It doesn't really matter how much have you prepared and everything, but you really need to know where to stop. You need to know what not to ask. One wrong question and your trial's gone. So that is very, very material, I think.
Trial is also about some mannerisms and attitude while doing the trial. Sometimes lawyers tend to intimidate the witnesses. Sometimes they ask so sweetly that witness just becomes parrot.
Yes.
It all, it's a
That,
very,
that absolutely helps from that. I think I could share one experience of mine. This was a older criminal law IPC matter 307. There it was a political tiff. An attempt to murder cross complaint was initiated by both parties, and I was examining the medical officer in it, cross examining the medical officer. The case was that my client had shot that victim, and for weird reasons, the police had also put into the charge sheet that uh, my client itself and his people had taken the victim to the hospital as well. So that was on record. And one right question to that medical officer from my end, I asked him whether the person who was taken to the hospital was in a situation that he was about to die. And he obviously said yes. He thought that I am falling in for a wrong question and the trial is now on their side. And my second question was that is it true that had he not been brought at that very moment, the person would have died, and actually my client saved his life, and the medical officer went ahead and answered in the positive. So that just one answer from the medical officer that my client in fact saved the life of that person and not really killed him, uh, helped. So that demeanor wherein the medical officer felt from my demeanor that I am actually not asking something which is going to be detrimental to the prosecution case, made him a little relaxed. And at the end, just asking him whether had that person not been brought to the hospital at that moment would have resulted in death really changed my trial, and we got an acquittal.
Completely agree, sir. Because the litigation is all about the what to ask. It's much sorry, what to ask. It's most important what not to ask. And even argument also, we applied the same formula that the most important part is about the what not to say while
Yes,
you're doing argument.
Especially when the judge is asking you a very straightforward question.
correct.
Yes, yes.
That reminds me, one time somebody told me an anecdote. This very important case, so many lawyers were appearing. Mr. Fali was arguing on one side, and there was a team of lawyers which had gone at his house in the winters, and there were so many people. Even his conference room was small for those people. He had a habit of going for a walk in the evening with a stick and a, because in the winters it becomes dark early. So he used to take a torch and a stick and he used to take a walk. So he returned from the walk. He said to the lawyers, "So how many trees are you planting?"
Yes, 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 yes.
It's a very
It's a Supreme Court case. Yes, 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 yes.
Supreme Court case and a very
Yeah,
famous.
yes, yes, yes. It's a
So
demolition of the illegal property, and they asked they about the. It's a Goa case actually. It's a, some properties built up in Goa. So it was a yes. It's a very famous case.
very famous case. I don't know
Yeah.
the facts of the case. I just
Yes, 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 yes.
So in the morning, when the court sat down and everything, the first question the judge posed was, "So how many trees are getting planted?" And everybody was flabbergasted as how did this happen that he asked the same question in the evening, and the same question as judge is asking. So it's important to know the judge also.
No,
Yes.
it's that's what Mr. Bhosale and I do agree with the one point. Why you need a senior at the very early stage of your
At the
career?
early stage of your career.
It's not just about the knowing the law. It's not about even though you know the good English, even you know good at drafting. It's not about the litigation. It is all about the how you have to shape yourself as an advocate. Then you need a mentor.
That's so true.
That's at least you have to do for the at least for the 1 year for yourself, just learning things. At least do 1 year. Spend your 1 year time as a junior. It's not you're not not everyone have that much courage to do 2 years or 3 years juniorship, but at least for sake of your own self, just start your practice with any senior and do at least minimum 1 year.
I would just like to add that when we did law, we were told that first year of your in practice should be devoted in the district court. Where that is where you learn the nitty gritties of law rather than
Yes.
the appellate courts. So now moving on, I would like to ask Mr. Khairnar, how did you decide to become an advocate on record, and what do you think the future looks like there?
Yes. Being a adequate and record, it's when even I'm not aware about the something like this, like the in the Supreme Court, if you want to be a file a case, you need a adequate and record.
I would like
So
I just like to interject just for the students, give them a brief idea on what
yes, what
uh,
is the meaning? What exactly do
why
you mean by the
the
adequate and
process
record?
of the 4 year waiting and everything, the
Yes,
exam
yes, yes, yes.
in brief.
So,
Thank you.
I may say that uh, as a advocate, I may say that when you start your practice for the first year, for the first 4 years, you have to do practice before the any court. Like it's not just about a district court or the high court, or even in a Supreme Court. It's about you have to have a continued practice for the 4 years minimum with any bar. Then you have to apply for the continuation of practice certificate which provided by your concerned bar where you register. So first you have to once you complete your law, you have to register yourself with your state bar. Even it doesn't matter which state you're in, but you have to first priority is about the registration of yourself as an advocate, registration of yourself in a state bar room. And then second is about the you have to continue practice for the minimum 4 years. So it's if you're doing any if you're accepted any job in the meantime, it will not counted as a practice. So it is just about the practicing. It's actual practicing. So it's like a presenting yourself in a court. So it is counted as a continuation of practice. So for first 4 years you have to do the continuation practice, and then after 4 years you have to apply for the it's they say there is a continuation certificate. So this person have a continuous practice for the 4 years, and if you don't have, then you have to wait for the more 4 years. But if your continuation practice, suppose you are done your law in 2020, then 2024 till the 2024 you have to continue, you have to prove to yeah, in the Supreme Court registry that you have a continuation of practice, and it is just one document which provided by your concerned bar, state bar. So this person have a continuation of practice of 4 years. Once you apply for that, you get that within 8 to 10 days, or some bars may provide in within a month. So it will time taking process for them, because they will check that whether you are really in a practice or something like that. It's a kind of verification of your practice. So once you get those practice continuation practice certificate, then you have to apply for the you have to approach to the one advocate on record who have minimum 10-year practice as a Supreme Court advocate on record, not just as an advocate, but as a advocate on record. So he given a one certificate. It's a commencement certificate. So with this commencement certificate along with your continuation certificate given by the your concerned bar state bar room, so those two documents you have to submit before the Supreme Court registry. From that day you have to do continue internship with the AR where you started your internship, because of 1 year internship with the adequate record before the appears for the exam. It's a mandatory for a year, because if you don't know the how to listing is happening here, because in a Supreme Court we have a different listing procedure. It's not in a High Court they have a supplementary list. Here we have a it's like a within the 2 days they have changed the things. So it's like a, because we have a miscellaneous day in a High Court. It's just like a in general listing over there. So for the learning those things, like how the listing actually happening in a Supreme Court, it's not just about the preparation of the matter, drafting something, but it's a very basic thing, which matter are going to be a list, or which type of matters are happening, which matter are going to be list on which day. So for that we have to learn through the your actual internship with the UR. So for that, because in a Supreme Court on a Friday and Monday are miscellaneous day, all the fresh matters filed between those 2 days are going to be listed on a very first day. So you have to must remember that which day is the miscellaneous day, which day is the final hearing day, and which matter as the regular hearing day. So for learning those things, you have to must have to present over here. So it's just once you once you start with your submitting your commencement certificate provided by your AR, and continuation practice certificate provided by your concerned state bar, you have to submit those before the Supreme Court registry. So and they will verify your documents that you are done your continuation practice for the minimum 4 years, and then they give a one email after the 1 month after verification that the your practice with this your XYZ your started with this day, and it's going to be completed on this day. And after the completion of the 1 year, you have to submit completion certificate along with your sanat. It's a registration of bar. So you have to submit your sanat and along with your uh, completion certificate. And once you submit that, you are to eligible for the examination. So it is just like the we say that it's a lengthy procedure, because it's 1 year for the preparation for the exam, and along with you have to learn for the actual court practice procedure. So it's just like a simple thing. It's not just a simple thing that the you can say that yes, in our colleges we just read before the 3 to 4 days, and next day we are going to be appear for the exam and it's going to be clear. No, this exam is all about the practical approach. It uh, it divided into 4 parts. It's like a drafting. So you must have to learn those things like the what uh, jurisdiction exercised by the Supreme Court. First, then second is about the which kind of matter filed before the Supreme Court, and what is the uh, perfect way, or what is the proper way to adopt the petition. Because here every petition, like even in an appeal, or if it is a statutory appeal, or even if it's a special leave petition, or even if it's a review petition, we have a specific format, and we have to learn those things, and it's not going to be changed at anyhow. So we have to learn those things within those 1 year during your internship time. So it is just simple that the drafting, which draft are filed before the Supreme Court. Then it's about the practice and procedure, how the Supreme Court working. Third is most important professional ethics, which we had a subject in a college also, but here we have a more focus on a misconduct of the AOS. If you are do something wrong in a court petition, or if he done something wrong in a filing, if he misled to the court in a facts, or sometimes even last month when Justice Oak was here, there was a misconduct happened. One AOR blindly signed the petition with under his senior's instruction. It's a Rishi Malhotra case. So they reprimanded the AORs also. So here we have to very care about the what we are filing and where we are signing. So it's a third subject, and the fourth and most important part is about the leading cases. So it's only focus upon the from the establishment of the Supreme Court 1950 to till date. What are the most important cases which shape the Indian judiciary and shape the Indian constitution? So it's very important for us that it is not just about the Keshwanand Bharti. We all knows about the Keshwanand Bharti, but till the reach of the Keshwanand Bharti, what are the other cases which are very important to understand the constitution? So it is just about the understanding the constitution from the development of the law and the judgment given by the Supreme Court. That's the most important thing. So that's the most important, and the most difficult task is about this examination is about the writing. Because right now you're in a student phase, so you can write anything, but the believe me, after the practicing of the 4 to 5 years now, you just forgot about the one thing, that is about the writing. So it's a bit difficult task. It's about the you have to efficient speed while writing the examination. So that's you have to very much focus about it, and simultaneously you have to think that the what is the law. And the difficult part is about this examination is about the um, those are the examiners are actually sitting judges of the Supreme Court and the senior counsel of the Supreme Court. And even though the who's going to check the your examination paper are also senior counsels. So it is not about the your college teachers who are giving the your sympathy. No, there's a no sympathy. Because when in my batch when I become we are only from the Maharashtra state. We are only 5 or 6 people over there who become a EOS. So it's very small ratio to become a EOS. But I must say that during this journey, I learned one thing is about when uh, doing my practice in a session court and then shifted to the high court and now in a Supreme Court. I may say that yes, there is a difference, and I may say that in a Supreme Court practice we have a much more discipline. We are very particular about it, that the you have to return those things in a particular way. You have to do it. It's not option for you, even though you are yours. No, it's not about the options. It's about the you have to do, and that's why you are yours, because you know those things. So those are things. And now I would like to say that why Supreme Court need a AOS and what exactly AOS do. Because of what, because of they are also lawyers. Then what make difference with the other lawyers? The most important difference is about the AOS and other lawyers is about the signing power. Because if any person want to file his petition before the Supreme Court, he must need one signature from the AOR. If it is not signed by the AOS, and certificate of the filing SLP or any petition not signed by the AOS, it is not going to be filed. It's going to be straightway rejected, or it's not going to be accepted by the registry itself. So why they having so much relying upon the AOS? Because the thing is about the when while we preparing for the examination, while we appearing for the examination, what makes different with the other lawyers? It is about the understanding the ex- what exactly required in a petition, and if something wrong, I put myself before the court. I do know the consequences. So it is about the you have responsibility. If even though I may say that on the point of responsibility, even though if my senior done something wrong in a front of court, they will not ask to the senior, not even ask to the my briefing counsel. It's the only one person responsible for the brief, and that's a AOR. So AOR is a completely accountable for the everything written in the brief. So that's why we need a AOS, and AOS duty is about the not just about the signing, but it is about the uh, what you are what you have to mention in a petition, whether it is if it is something like this, if it is not a genuine case, it is just like wasting the court time, then also as a your we have to very clear about before filing that yes, this case is about the just wasting court time or something, which is we say that the uh, PIL matters. It's just like publicity stunts. So we have to very clear. So we have to say straightway to the client, even though we are getting brief, but we as a AOS, we are duty bound. It's a moral duty bound, and most of the AOS, we are genuinely say that no, we don't want to be a part of this petition.
Sorry, Mr. Khairnar, to
Yes.
stop you. We are about to, the
Yes. Yes.
meeting is about to close. I just want to have a quick question for for Dr. Bhosale. Can you share something about your entrepreneurial journey and uh, how your educational and entrepreneurial journey had, uh, and you handled it so beautifully during your career, and give some suggestions to the students?
I think as a lawyer, I figured that understanding businesses well is something which was very crucial to becoming a good economic offenses or white collar crimes lawyer, and that got to me very early. So I think I do understand businesses by now as well, or at times even better than the people who are actually doing it. That has somehow been my passion, and that really helps me even in my courtroom. When so most of the times you must have also experienced that the judges are not at all adept to the real world business, and they don't really understand what are the illegalities which are caused and whether they actually were irregularities and not illegalities in the first place, or a bad business decision or something of that sort. And the police have just gone ahead and filed some charges of economic offense. So having to understand judges, make them understand what are the issues behind a certain business is something which I started developing an interest on really early, and that's how by now I think I'm very naturally inclined to understand the business very well. That has helped me, of course, running our law firm, which has been around for 45 odd years now, and taking it over and understanding how to deal with it, in spite of being a litigating lawyer, is something which uh, really really needs an understanding of business as well. Apart from it, I've been a very active angel investor as well everywhere, and I do interact with a lot of founders and a lot of businessmen. So yes, that overall shapes your personality. I feel it helps. So I've always believed and seen from an early age as well from my senior Mr. Manishinde that as a lawyer you're going to grow if you interact with the society in general. It I have seen too many lawyers who are into the bar only, they are into the courtroom only, and their personality beyond our profession doesn't really shape, and that somehow becomes your roadblock. So interacting as much with various types of people, various angles of the society, various businessmen, various professionals, and so on and so forth really helps you in rounding off as a good lawyer as well. And that's how I have been dealing with it.
On that note, COVID has really forced lawyers and judges and courts to accept technology and involve it in their daily work, into their daily workings. So,
Yes.
how do you think that technology is going to help lawyers and students in future?
it's it's absolutely going to change the picture what we are seeing today. In no way it's going to change or replace lawyers, but it's going to definitely change the way we work. It's going to make sure that we only focus on what matters, and that's applying our brain. uh, Sundry things like going through large documents, uh, failing at your research because you don't know how to find a case law, are things which are going to be redundant in near future. Machines are now smart enough to tell you what is the output that you should be looking at, and that clutter that is there around a lawyer, that is definitely going to reduce. And now you can't really take. It's also going to be a negative that many a times we so say to clients, the brief was too large to read in this much time, I was too busy doing abcd, but all those tasks which we often said were time consuming are going to now be done in a fraction of a minute by technology, and that's definitely going to change the way we work. And if we keep looking at technology as our enemy, in no time we'll perish. We have to look at it as our uh, friend and make sure we use it as much as possible.
Yes.
That's so true. Like even large corporates are using technology to reduce their contract review work a lot. On that note, somebody has asked a question, Mr. Ashwini Kumar. What is your opinion on the recent judgment of Supreme Court on the 3 years practice rule?
I'm completely agree with the Supreme Court opinion because the judges are those because of academic knowledge is different thing, but when you are dealing with a real case, then you need some lawyer experience, like the what exactly application of the law and what is the social impact if you pass such judgment, what it will the impact to the society, and for that understanding you must went to the bar, and from the bar then you come to the bench, then I may say that it's a good way to be become a judge. So I may say that yes, I completely agree with the Supreme Court opinion.
I would say you should increase that 3 year limit. It's too less. Even 3 years. Yeah.
Yes, yes. So actually that's a main because the practice is why important, because even though become a Supreme Court adequate record, why they are having a criteria for the 4 year minimum practice and 1 year experience with the adequate record, because
Yes.
they know that we don't want to be worse the what we are actually doing the good. So
That's so
that
true. There is a in the law legal circles. There's a judgment of a which is being circulated where he has remanded 14 years of judicial custody, and one of the accused was asked to stand in the court with his hands up for the whole day.
okay.
I asked the collective counsel to share that judgment with you. It's become a laughing stock in some legal groups here. But
It's
It's a
it's
contempt actually. These things happen in a contempt cases like a
district court
civil
doesn't have contempt power.
because sometimes I don't know, but because of these things have happen only in a that's like a civil imprisonment, or sometimes they do that they just do stand before the court for the whole day. It's just simple punishment. I don't know this kind of punishment not even mentioned in Indian Penal Code also.
It's not. It's very funny. I'll share it with
Okay.
everybody. Please have a look at it. It's funny.
yes. Experience is very material.
It's very very material.
Become a judge.
That's why actually why we are a collegium system. Though those are having a practice and knowledge about those particular court, who are having a good practice at the Supreme Court, or who are having a good practice at a High Court. Why we want those person become a High Court judge or Supreme Court judge? That's the main motto. That the why we need experienced people. It's not about, that's why I'm saying that it's not about the academic knowledge. It is about a practical approach, and the practical approach toward the resolving the things which are going to be happen before the you, and the putting those facts, putting those cases before you have to deal with those briefs, and that for that you need a practical experience.
So true.
And
So
unfortunately, in India, there are few very serious issues like large economic offenses matters unless they are tried by PMLA courts, eventually attract cheating sections, and they are tried by magistrates. They don't understand anything which goes on to the charge sheet, which runs in thousands of pages, complex international transactions, thousands of crores of allegations, and these young kids who are sitting on the bench with no experience end up making a mess out of it. So yes, definitely experience is very material. Uh, I remember in one of my matters in my early years, I was arguing a defamation private complaint before a magistrate. After arguing it for an hour, the magistrate asked me whether why didn't I approach the police station for a defamation FIR, and the magistrate didn't know that it's a non-cognizable offense. The situation is that bad, so it's necessary for everyone to have experience.
Exactly. That's why we're saying that the experience is much more even. That's some people are opposing the collegium system, but we know the as a practicing counsel in a Supreme Court, I must say that the why we need a collegium system, because the most important part is about the we need an experienced person, not just academically good, but about the resolving the things. That's why that's the main motive. But I don't think so. It's going to be a now. I don't know what is the government motive behind it. They want to oppose those things, but the reality is about very different. As a practicing lawyer, I may say that the we want experienced person to decide our cases. If those are don't have experience, don't expect the good judgments. It's a very simple.
That's so true. That might also help us with the long pendency of cases that we have. If the district court matters get reduced or handled properly, might help us in pendency also.
That's why people will to approach to the Supreme Court. If something they don't did not get in a session court or high court, they have to travel towards the Supreme Court.
Yeah,
If
but for
they
a litigant, it is very harrowing to travel to Supreme Court because they have to jump the hoops to High Court, multiple benches and everything, and then reach Supreme Court. It's taxing in way of money and everything.
exactly, so that's why we need a good judges.
That's so true.
But the reality is about the nowadays people. I must say that the students are more attracted towards the like sitting law firm jobs or attractive corporate practice rather than litigation or the judges side. That's even Justice so on his last speech when his return speech he concerned about it that the I may feel from inside that the most of the people are just dreaming about the securing his job at the topmost law firms rather than thinking about the litigation or doing judge's job, because the reality is about the in initial days we have to struggle. It's not about the generation second first, but it's about we have to struggle. We have to struggle for the learning, struggle for the getting matters, and struggle for the getting the orders. So we say that yes, that's make impact your life or your initial days. But the I must say that even I don't know, Dr. Chinmay will agree with me that the even though we call it struggle, but I must say that the we are enjoying our litigation practice
Yes.
till date, from the first day to join the bar to the till date when become a you are. I must say that the I'm the same person. I'm just differences about the having no briefs to having briefs, having the different type of arguments. But the most important part is about the from inside. I'm just litigant lawyer and I'm student.
Yes.
That's that's the only thing we can pursue or continue as a practicing advocate.
That's so true. So,
Yes.
from passion, persistence, great
Yes.
resilience, what do you think are the other qualities that we need for sustaining in this field? Lit-
Patience.
First, yes, first is about the reading. I must say that the even though you like it or don't like it, you have to develop your habit as a reader. You have to habit about the reading, and the most important thing, even though while I'm traveling in a metro, the most important thing I feel that the, even two people are doing a conversation or a discussion topic about the politics or something. As a lawyer, we are very much about the ability to observe the things. It's about the observing what exactly happening in a society, so that make you make a different person, because of why it's very important, because of those are the things which you think about the what other people thinking about the same facts, but they have a different opinion. So why it is important? Like they, even though he's arguing the same facts before the court, you do know that the even the same facts, one person going to agree, one person going to disagree. But the most important part is the presentation, because when the two people are doing discussion, one person always make a good point, and that makes sense. So if you're observing those things and you putting those things in your practice now, I must say that you become a different person. But for this, you need a that much observation skill. You have to very patiently listen to the people, and the most important ability to observe, even though it's a simple conversation, but it is about the how one person convinced the other person for this doing same thing. I think that's a very important for me. Yes.
Dr. Bhosle, any insights at your end?
I think reading, yes, definitely. Everyone needs to read a dedicated set of pages or judgments every day. I'm not kidding. I in this digital age as well, I think I have a habit for the past 15, 17 years to maintain a set of notes which now itself runs into hundreds of pages of the judgments I read. I categorize them in the requirement of my profession and my practice, and I make sure I read a weekly every week from first page to the end, last page. Does no googling, no control F, nothing. Read every page from every comma to every full stop, and that's how you're going to learn. Second is patience. You need to be extremely patient to make it in this profession. And thirdly, as I mentioned before, you need to be a very well-rounded person. You need to interact with various sects of the society, speak to people beyond law, interact with them, understand how the society is functioning, and that's what is going to eventually help.
Right.
Thank you, Dr. Bhosle. There's a question which is being posed, especially to you, Dr. Bhosle. It says that what is the right way to build CV for getting into law colleges abroad?
One is they really, really look into your academics uh, pretty well. They'll expect a certain degree of academic excellence. Marks as such don't matter to them because every country, every law college, every university has a different way of grading. So maybe in some university, having a grade of 7.5 on 10 might be bad, and another university you might be a university topper. So it's more than grades; it's that they'll check whether you're in the top 3 or 5 percentile of your law school. That is something which will help. Uh, Showing more of your character as well beyond academics is going to help. So if you could show what are the aspects of your personality when it comes to arts, social service, doing various things in your law school, be it drama, be it so on and so forth, also does definitely help because with A leagues law schools abroad, they definitely want character, not just academic excellence. To be stepping into will definitely help you.
Yes, even I agree with that, because the while making CV, you have to do one very important thing is about the you have to mention that the all our students who all are doing the study, and that's all are doing. But the thing is about the what extra you are doing. So it is just about the how much you connected with the ground level. It is about the what you how you can connect it with the social organization. For me it's a very important, because if one person is doing internship with the rather than just the advocate office, but doing the actually internship or the work with the any NGO who are actually doing the some social work, it's very important. Why? Because the thing is that the in your initial days, if you know that the what exactly happening in a society, and how you know, because it's not just happening in your office or in an advocate office or in a courtroom, it's happening in the ground reality. And this social service organization, if someone doing the working for the orphans, some are working for the domestic violence victims. So you guys have a that much connection. You guys have a much more knowledge about the what exactly scenario, what exactly present situation of the society. So I may prefer that rather than academic, I may prefer that the person who having a touch with the actual social issues which are happening or going to happen in a society. So it make difference for me. Because academic, I'm going to say that the yes, academic, even a backbenchers is going to be good lawyer. So it's not just about it. It's about the you know the situation and you know the how to deal with those situations. Those not written in your law book. So yes, that's make different from the other candidate.
Thank you, speakers. I have just one last question. I will just quickly ask you to answer it. Be a good observing the courtroom mannerisms, and observing people in general also helps. To have a well-rounded personality also helps. Networking, having good connections with all kinds of walks of people in the society also helps. Now, just this one last question, Lloyd. This legal profession is a very demanding profession in terms of having a work-life balance. Uh, every lawyer, every senior that I have seen with a bit of success, I don't think from afar it doesn't seem like they have a work-life balance. They just strive at it regularly. So, some strategy, some input that you think can be used to, like some people meditate, some people have a routine, like. Um, I am forgetting the name of Mr. Sham Diwan. He's a senior advocate in Supreme Court. He started his career in Bombay. He has this habit of running every morning at 5:30 or sometime in the morning. Some lawyer have a habit of meditating in the morning. Some read for pleasure. So there is a routine for every lawyer who has um, who has excelled or has had a balance, has enjoyed the profession. So while you're enjoying the profession, having enjoying all aspects of it, some inputs that how you manage all it to have a well balanced life or strategy.
I think one thing is very certain: if you want to be a litigator, there's no concept of work life balance. But in that entire chaos, you have to make sure that you keep your sanity in check. And is that you need to find one passion of yours and definitely try to enjoy it every week, every day if it's possible. For me, it's exercising. I make sure I work out at the given time. I may work even after my workouts are done. Obviously, prior to them, I'll keep working, but nonetheless, that particular time that I have decided to give myself, I make sure that I go ahead with it, because there needs to be some sanity check. So if you, for some, it arts work, some go ahead with music, some go ahead with reading for leisure, some go ahead with traveling maybe, which works for them. They'll work for 300 days and then for 50 odd days they'll be off the grid absolutely. So you need to find what is your sanity check, and that's very very material. But yes, never expect a so-called work-life balance or a fixed timeline if you want to be a litigator.
Yes, yes. Even I agree with that. There is no work balance for the lawyers. Even in a litigation, it's really impossible. We don't know the how much time we have to spend for the one case, or even sometimes we have to work for the whole night if we need to file that petition on the very same day.
Correct.
So I do know that, and even but I must say that even I agree on the one point that even I'm following that one. The exercise is very important. Even today also I'm focusing because of, I do know that even I have to practice efficiently at the age of 60. I have to focus on my health today itself.
Correct.
That's why. Otherwise, it's really impossible.
Correct.
Especially to run between the long corridors.
Yes, it's a part of the profession. It's even though in a Supreme Court, Mr. Kapil Sibal is there, and even Sham Diwan sir is there. They're all doing those things. They're running between the corridors, even at this age.
This age.
So it's not about the even the you're not doing the exercise. You have to do that one. So it's not a part of the exercise, but uh, it's about the balancing your life. It's a maintaining good health because we have it's like the we face so much medical issues at the later on after the 50. That's a reality due to the our we are not following good diet, not following the exercise. So it might be the part of our lifestyle. But I must say that from the day one, from the year where you are, you start focusing on your diet and following the good health habits. I must say that it's good for you for the long term practice. Even though you have to practice at the 65, you have to that much efficiency in order to consume any medicine or follow any treatment. If you want to be a good balanced life, I must say that you have to start today itself. It's not that
Absolutely.
that particular day you are going to start, but it's
Absolutely.
about going to start on a very first day.
Mr. Khairnar, there's one more question. I'm sorry I missed it.
Yes.
There's one common mistakes law students should avoid
About the starting his practice or the for
in the
making.
college, in the student life.
Yes, in a student life, I must say that most of the people are more focusing about the moot court competition, doing internship, or doing what other activity. But I must say that the first you guys have to start enjoy your life in a college days also as a student, because after the core after the you become a lawyer, you never get those days back. And as an academic, I must say that the most people are try to read the fancy draft like they are thinking like the one day I'm going to be doing a job at a renowned law firm. So for that I have to prepare myself. Don't do that things. When at the when at the student stage, just do one thing. Think about you're going to be a lawyer. You're going to be start your practice as a litigation lawyer. So I may say that they just focus on what you're going to do. So at very initial stage, I may say that they just focus on uh, just developing yourself as a lawyer rather than just doing job seeker. I may say that they just think about you're going to be a start your own practice, and it might develop you. Even though eventually, even after 1 year or 2 years, you're going to be start your you decide to take a job, but it it will give the something exceptional case with the other candidate. So I may say that you have to read or follow the habits just like a lawyer. So I may say that you just follow your own way to become a lawyer. That's and people will what student will mostly I got some messages from the on a LinkedIn. I got some messages from the law first year, second year law students that they want to internship with the Supreme Court. I must say that how it can be possible. It's not just about not getting opportunity. I must say that when I done my law and I become a 4 to 5 years practice, then I'm thinking about the Supreme Court. At the student level, I don't even think about the Supreme Court. I'm not. It's not about the challenging your ability. It is about the you have to learn the basic things. It is about the where to start. So even though at a very initial stage, you guys have to think about the where first phase of the litigation will start, or first phase of the basic any case will going to be happen or file. So I may say that just doing the fancy practice or fancy internship with the Supreme Court or High Court lawyers, just do one thing: join your if you're in a Pune or wherever you are, just do or join the chambers of the advocates who are doing the court practice in a session court or the judicial magistrate first level, so JMFC, or it's even a junior judges. So go over there, learn the basic things, because the two things are very important at a very initial stage, where you guys will get the opportunity to understand the what actually common man facing. That's the most important. As a lawyer, we must know the what common law are facing. So for that understanding, you guys rather than just thinking about the fancy internship with the renowned law firms, Winner High Court or Supreme Court, I may say that it just learn the basic thing about the where actually the litigation is going to start, and it's a because of it's a nowadays, or I may say that very later on it's a developed practice about the doing the job in a law firms, but the at initial law is just about the doing the practice in a court. So it's not just about the traditional, it's about the developing yourself as a law student. So as a law student, what even though you are doing a job, you have to do one thing, and it's about the understanding the law, reading the law, and then drafting the petition according to the facts and the law. So where you get those knowledge. So it is start with the basic code, and I may say that they just start with the local codes. I may say that the sessions or JMFC.
Thank you.
Yes.
Thank you, Mr. Khairnar. Sandeep, you want to ask something? Sandeep? Sandeep, do you want to ask something? I think she's disconnected. Um, no, you're not audible.
I think she's on mute.
Sandeep, you're on mute. Collective Counsel, please direct Sandeep to ask her question on LinkedIn or other channel if possible. Thank you. Thank you, Mr. Thank you, Dr. Bhosale. Thank you, Mr. Khairnar, for the wonderful session.
My pleasure.
Yes.
It was
All,
a great learning curve and interacting with you both.
and all the best to Collective Counsel. It's a great thing that you're trying to handle. And it was great interacting with all of you.
Yes, and even I wish very well about the thing is that it's very important for the platform for the first generation lawyer, not just about the first generation, but I must say that for the lawyers who actually want to practice, because it's a very difficult task for them that how to start and where to start. So this can be resolved there. I may say that the internal anxiety about the whether I'm going to be a lawyer or whether I'm going to start my practice. It's so when you understand those things on a very initial days, like if you're in a fourth or fifth years of law, and then you know that how to handle the things, then I must say that it will shape your career at a very initial stage. That it will make change your mind if you're thinking about the for first years I'm going to do the job, and you understand that the what's the importance of the litigation practice. I must say that this is the stage where you can understand that the importance of the litigation practice. Yes, that's a very important.
Thank, thank you, speakers. Have a wonderful weekend. Thank you, students,
Yep.
for joining us and hearing us.
Thank you. Thank you.
Okay, okay. All the best. Thank you.
Good evening, everyone. I am Kritika, a law student and a volunteer from the Event and Program Department of Collective Counsel. It's an absolute honor to be part of today's session, and I'm truly grateful for the opportunity to engage with such accomplished professionals and curious learners. On behalf of the Collective Counsel, I extend my heartfelt thanks for this wonderful and inspiring fireside chat, Law and Beyond. law school journey and beyond. First and foremost, I would like to express our deepest gratitude to our distinguished speaker, Advocate Tushar Khairnar, advocate on record at the Supreme Court of India. Thank you for sharing your rich courtroom experience and guiding us on how to navigate the world of litigation with clarity and purpose. Dr. Chinmay Bhosale, co-founder and partner at SRB-OJAS, we truly appreciate the practical wisdom and mentorship you have shared, especially around building focus, seizing opportunities, and staying grounded during law school. A special thanks to our moderator, Advocate Richa Bharadwaj, Legal Counsel at Tech Monks. Your thoughtful questions and graceful moderation brought flow and depth to the entire session. To our organizing team at the Collective Counsel, thank you for tireless effort behind the scenes, from planning and communication to execution and coordination. Your dedication is what made this event a success. We are also deeply grateful to the mentors, professors, and institutions who constantly support platforms like ours. Platform that aim to bridge the gap between legal education and the legal profession. As we close, let us carry forward a few takeaways. That law school is not just a phase but a foundation. That mistakes, when reflected upon, become stepping stones. That mentorship, discipline, and clarity are not optional, they are essential. Before we end, we kindly request all the attendees to fill out the feedback form. Your thought matter greatly to us. Certificate of participation will be provided to those who complete the feedback form. Once, thank you once again, each and every one of you, for making this event a memorable one. We hope to see you again in our future session. Until then, stay curious, stay driven, and stay connected. Thank you and have a wonderful evening ahead.